SJC-10405, Commonwealth versus Francis Lang.
May it please the court, Ruth Greenberg for Mr. Lang. With the court's permission, I'd like to spend the time we have today together on the arguments under Ribeiro and Federici, and then speak to 233E. I do just want to say the one thing, which is the Commonwealth is correct, that the standards of recklessness are different for third-prong malice and for manslaughter, and I apologize to the court, and that I'll leave that question. I want to talk to you today about Ribeiro, which is contrary to the Commonwealth's assertion, still good law, and has not been sub silentio overruled. I draw to your attention the supplemental appendix, which I filed with this court, which is a psychiatric mental health record, over a pound of records, 700 pages of records, a 17-year history of mental health treatment in the Bureau of Prisons. I draw your attention to the list like beads on a rosary: lithium, Depakote, Risperdal, Trilofan, Neurontin, Seroquel, Trazodone, Remeron, valproic acid.
So in terms of the diagnoses and how it would translate into state of mind or behavior, is it anything that defense counsel didn't already know? I mean, is there some diagnosis he didn't know? Is there some, I mean, doesn't this all have to do with poor impulse control?
Judge, trial counsel knew nothing. Trial counsel did not have this.
Is that really so? That's not what the judge said.
The judge said that trial counsel was alerted to the fact that the defendant had a mental health history.
Now, what did defense counsel testify to?
Defense counsel testified that other defendants had told him that the defendant had a mental health history, that the defendant had told him himself he had some problems with mental health, that there was predecessor counsel very briefly in this case, Peter Parker, who had filed a motion saying that the mental health records were large and he would need a social worker to go over it. And what trial counsel testified to that was, as a matter of policy, he did not look into mental health records or do mental health investigation because mental health defenses were not successful.
So if did prior counsel have all these mental health
No,
records?
prior counsel was only prior counsel for a very
But said he
brief
needed
period.
somebody to go through them because they were so voluminous?
Right.
It suggests he had them or knew.
No, it suggested that he knew there was a 17-year history. The defendant had been a federal prisoner for a very long time. He maxed out his federal sentence. During the whole time he was in federal prison, he was treated with antipsychotics, anti-seizure meds, Seroquel, this whole list of things. And then because he maxed out at the federal prison, he was released with no medications whatsoever.
But
He was only
you
out
hired
22 days.
Excuse me, you hired an expert in connection with the motion for new trial on the basis of ineffective assistance of counsel, right?
Yes.
And what diagnoses were the result of that expert's testimony?
The expert said several things. He said that he basically described it as if Mr. Lang really had a frontal lobotomy, that he had no frontal network control. He was unable, and this confirmed the BOP diagnosis, which was in the record. He had, what BOP said and what Dr. Spears confirmed is that he really had, and he quoted from BOP, no ability to interpose thought before action.
So no impulse control.
None. And he did a series of neuropsych tests, which it wasn't like no impulse control, I get mad if you get mad at me. It was no impulse control, I can't read the word green if it's printed in red. Not an emotional fact of no impulse, but more like a massive systemic cognitive deficit, leaving him not in the bottom 10%, the bottom 1%, but the bottom 10th of the bottom 1%.
Do you agree that there was a viable self-defense theory?
Yes, I can't disagree that there was not a viable self-defense theory, but
And that something like this would be something that a reasonable lawyer could see as undermining a self-defense approach. Because if you have no ability to control yourself, aren't you more likely to have been the first aggressor? If you have no ability to control your impulses, how can you say you responded reasonably in acting in self-defense?
it is occasionally true in some circumstances that impulse control disorder will negate or not work well, not complement a self-defense case. But it is also true that a lawyer is not permitted to make a strategic decision out of complete ignorance. As a matter of federal constitutional law and state constitutional law, a lawyer has a duty to investigate a defense which is a complete defense. And the law uses the word, and it's in Rubio, a substantial defense. And substantial doesn't mean a defense I like or a defense I might not prefer. Substantial is defined as a matter of law, as a defense which, if the witness is believed, provides a complete defense. And actually,
Talk
there's
about your interpretation of Federici again,
I'm sorry, Judge, my interpretation of
the Federici case?
Federici. Yes,
Yes.
let me speak both to Federici.
Well, let me just focus you for a minute.
Sure.
The Commonwealth's brief argues that you completely misinterpret that case, that it's not about, as you argue, the defendant's right to say that I don't want to do that. It's about a defendant's right to decline an insanity defense. So if that's true, where does that leave the force of your argument about this, the point that you're starting on right now?
Twofold. One, the Commonwealth reads Federici wrong. The right to say yes or the right to say no has to include the counseled right to make that decision. And counsel can't assist the client in making the decision whether or not to present a mental health defense unless counsel knows what the mental health defense is. So the counseled right to decide whether or not you want to spend some time in a mental hospital or spend your life in prison, a choice which this court has given to the client and not to the lawyer because the consequences are so great, has to be made by somebody who knows what the chances are of winning or losing one way or the other. So it really is combined with the Rubio question, and it all goes to your lawyer can't help you make a decision unless they know what the record is, and the lawyer can't make a decision himself without knowing what the record is. It's impossible for a lawyer to be functioning in the role of counsel as guaranteed both state and federally with a client with a 17-year mental health record this serious, this severe, of which he is on notice, and not even look at it because of the belief mental health defenses don't work. And I didn't make that up. It's in footnote 5 of Commonwealth versus Rubio specifically. And footnote 5 counts as part of the decision. It's not dicta, and it says the fact that mental health defenses are not often successful is, quote, irrelevant. So both Federici and Robirio say the lawyer has to know. One, because even assuming the choice were up to the lawyer is not making a choice unless he knows his record. And in terms of the person making the choice, the person can't choose to accept or decline in a counseled way unless the lawyer knows the record. So a lawyer who just says categorically, oh, mental health, not interested, is not doing for his client what the Constitution requires. And you can look.
So your position is that the ball game is over if we conclude that Mr. Sheketoff failed to make appropriate inquiry into the mental health of the defendant and failed to advise him of the possibility of pursuing a criminal responsibility defense. That's, in your view, the ball game is over if we find that.
Given Dr. Spear's testimony, which supported a complete defense.
Okay, but what if, so let me give you another alternative way to look at it. Let's assume that, for the sake of argument, that we grant you that Mr. Sheketoff should have made inquiry into the mental health defense and should have conferred with his client about it. If further analysis of it determines that indeed, had that been done, certainly a responsible and competent lawyer would have come to the conclusion that Mr. Sheketoff did, and that his better course of action was to do exactly what he did, and that the defendant was not inclined to be pursuing a criminal responsibility defense based on what he has said after trial, that it ultimately would have turned out to not matter, that the outcome of that appropriate inquiry would have been to do exactly what Mr. Sheketoff did and essentially proceed only with the self-defense argument.
Judge, I'll come back to that in a moment. Let me answer it in two parts. As to the first, that would be Osborne versus Commonwealth, which is 378 Mass 104. It's actually on page 36 of the Commonwealth's brief, together with Hill versus Lockhart, because the defendant's claim is federal also, cited on page 35 of the Commonwealth's brief, and both good law and Robirio itself. Robirio clearly says what I say and what you just said. And as to the state of the evidence...
Sorry, you can't say both, because
I'm sorry.
what I was saying would mean that you'd probably lose.
Robirio says if the lawyer didn't look into it, and the lawyer should have, and it would provide a complete and substantial defense, meaning it would provide for a complete acquittal, and there is evidence later supporting a complete acquittal on that basis, that is game, set, and match. Yes, that is my position.
Even if a responsible attorney would not have pursued that course, and even if it is unlikely that the defendant would have allowed him to pursue that
And
course.
I answer to that last part that there is no evidence that is so. And the Commonwealth,
Meaning that
I
you
was
say that
surprised to
we
see.
should discount entirely what Mr. Lang said to the psychiatrist during the course of the motion for new trial, to say that I don't want to go to Bridgewater. It's bad enough to be where I am, but I'd much rather be in prison than be in Bridgewater.
well, we have several layers of difficulty with that. One is Dr. Walters communicates by mental telepathy. Two, that
goes to credibility.
Okay, well, it does.
But there's a difference between his evaluation versus his reporting of what the defendant said.
Well, maybe. And also, that document from which the judge quoted, I was surprised to see it quoted because it wasn't admitted. It wasn't evidence at the hearing, and therefore there was no cross-examination on that question. If you look to the record, you'll see that the document was offered by the Commonwealth, the defense objected, the objection was sustained, and the document was not admitted. So it wasn't in evidence, which made it quite surprising, and therefore no cross-examination on the topic. And you'll note also that the defense objected to the interview by Dr. Walters. The defense objected because there was no relevance to Dr. Walters' interview. Because Commonwealth versus Ribeiro says, if Dr. Spears' testimony is admissible and it provides a complete defense, it's to be expected that the other side is going to find some doctor who will say he was responsible. We offered to stipulate to it, and then we asked to have it videotaped to see what the defendant actually said, and that was denied. So what Dr. Walters asked and said to the defendant to elicit that response, assuming it was not elicited telepathically, is not recorded. We don't know it. It wasn't admitted. It wasn't evidence before the judge. There wasn't any opportunity to cross-examine it, and there's no real reason. Court can't rely on it. There's no reason. There's a lot of discussion, too. There was before Judge Brady, and the Commonwealth argues it again without citation to authority, that the defendant had to commit to presenting a responsibility defense in a trial in the future in order to gain relief on grounds he was ineffectively assisted by counsel at the trial that he had. But there isn't any such rule. That's what Judge Brady said, but there's no authority for it.
But that's sort of a side point, it seems to me.
Maybe.
The question is whether or not there's evidence that the client already made the choice that you're saying needs to be made.
But there isn't any evidence of it. And he doesn't have to make that choice in the future.
I'm not saying making it in the future, but I mean, it seems to me that he's made his choice. If this is in evidence, it seems to me that you can read it as saying that he never wanted to go to Bridgewater and spend his life there.
You could, but then you'd have to remand it for another hearing for Tolly Walters to be cross-examined on the issue, as that evidence was not subject to cross-examination because it wasn't introduced.
Was there any indication in the examination of defense counsel that he had had discussions with Mr. Lang about the defense?
Yes, he said he did not, there's an affidavit, it's cited in the, yes, I'm sorry.
Mr. Sheketoff?
Mr. Sheketoff testified he did not discuss it with the defendant. The defendant brought it up and he rejected it out of hand, that the decision was entirely Mr. Sheketoff's without consultation with the client.
Who brought it up?
Mr. Lang.
That Mr. Lang brought up the defense and he rejected it out of hand?
That Bob Sheketoff rejected it out of hand because he always does. That as a matter of policy, the defense is not successful. And that's exactly the reasoning this court specifically rejected in footnote 5 of Ribeiro.
And more precise to say that he said he will not do it when there is another
any
defense?
Other viable defense. And there was some talk about not having inconsistent defenses, which is why I pointed out to the court that he was already offering inconsistent defenses.
Well, that's not really so. I mean, it was just the business about identification. That wasn't really a serious defense here.
I don't think.
I mean, he never acknowledged that the defendant was the guy. But I mean, it's clear from the transcript, isn't it, that the defense was really self-defense.
It was primarily self-defense, but there were a lot of roles in this trial that this mental health evidence could have played. What it can't be is ignored. It can't be just decided in advance of the fact it won't be useful. It goes, for instance, to cruelty and atrocity.
How?
Because intent to be cruel and atrocious is part of cruelty and atrocity. Mental impairment is a factor to be considered by this, as is ruled by this court on cruelty and atrocity. It goes to mitigation. It goes to all kinds of sentencing. It goes to...
For first-degree murder?
Under 233E, as we are well aware, this court has the power. I think, we have a lot of we have a big problem with people with mental health issues in the criminal justice system. We have a lot of cognitively and emotionally profoundly impaired people in the criminal justice system because the mental health system has failed it. That's not news to you, and it's not a radical thing to say in this court. What protections are there for these people? They have lawyers who are supposed to see if their serious mental health problems provide a defense. And then we have 233E review for when the lawyers bring the matter to the attention of the court. And not everybody's mental health issues can be easily excised. It's easier to see in a case where a person has a brain tumor and then you take the tumor out and the person is better. But mental health disorders on a cellular level, on a chemical level, are every bit as meaningful and as real and as troubling and as exculpatory as a mental health problem created by something which can be surgically excised. It's not a joke in this case. This is not a recently fabricated mental illness light. This is a person at if Dr. Spears had testified at a trial and said, this man has been on major antipsychotics and anti-seizure meds for 17 years, and then we let him go, and he walked the streets for 22 days, hollering up and down, sleeping 2 hours a night, that he had the impulse control of an 8-year-old, that his meds had been removed and nothing put in their place, and it was on that night he acted in this way. Don't you think that would have been a substantial factor in the jury's consideration? And isn't it, and shouldn't it be in yours?
All right, thank you.
That's my argument.
Good morning, may it please the court. John Zanini for the Commonwealth. In the motion for new trial hearing in the transcript of April 2nd, 2012, on page 203, Dr. Walters testified that she asked the defendant regarding his interview with Dr. Spears what the purpose was, and that the defendant said it was about criminal responsibility evaluation. And he said that Dr. Spears talked to him, quote, about an NGI plea, end quote. The question was, when you say NGI, were those the defendant's words? Those were his words, yes. He also said to me, quote, I'd rather stay in prison right now than be found NGI, end quote. It's on page 203 of the transcript. Assuming that the defendant has the right to choose, he has chosen. His choice is to stay in prison rather than use a criminal responsibility defense. I would also...
So does that go backwards as well? I mean, is that a fair implication that he had made that choice in the past?
No, but this gets to the issue of whether it would be fair or palpably unfair to grant a defendant a trial for the failure to investigate and present a defense that he will not use in the future, has no intention of using, and does not want. He should be denied that motion for new trial when he claims he could have raised this defense, he didn't, and by the way, I have no intention of using it in the future.
There's a difference about not intending to use it in the future and not having had the choice in the past.
There is a difference.
If the law requires that he have had a counseled choice in the past, that really has no bearing on that.
Well, I would disagree with that because the law requires he have a fair trial with a reliable result. And he's entitled to competent counsel and not a perfect trial and not an error-free trial and not perfect counsel. And it's palpably unfair to grant someone a new trial based on the failure to raise a defense that they will not use. I would also suggest that here the duty...
Has there ever been a case which makes that point? You cannot grant or ought not grant a motion for a new trial if the defendant will not agree to raise that defense at a new trial?
Not that I'm aware of. I would also suggest that there...
And how would it work? I mean, let's assume that there's a grant for a new trial, and we get to a new trial, and the end of the trial, the judge says, you never raised the point that you got the new trial on. I'm going to reestablish the earlier verdict because it turned out that it was done in error?
Yes, this court could say that, at least on a first-degree murder case under 278-33E, you know what? This is about justice, and there's a grave injustice to granting a new trial based on the failure to pursue a defense that you will never pursue, and you have chosen not to pursue.
I'm perplexed with your answer to Justice Lang, both as to that point, but as to your earlier point. Why can we not infer that this would not have been his position at the time of the first trial?
Actually, I agree with you. You can draw that inference. When he speaks in the absolute terms that I'd rather be in prison than be NGI, you can draw the inference that his state of mind today is the same as his state of mind yesterday. That's his belief. And in fact, you know, if he doesn't want to be labeled criminally insane, assuming Ribeiro gives him that right, he's exercised that right, and you can draw the inference that his state of mind would be unchanged yesterday, today, and tomorrow about that label. So I do agree with you.
Is there anything to suggest that he was any more counseled about that position than he was earlier before the trial, when that decision was made for him by his attorney, Mr. Sheriff?
Well, I think you can draw that inference from the fact that he was interviewed by Dr. Spears, that he was aware of what the interview was for. As he says, it was about a not guilty by reason of insanity and NGI defense, that he had new counsel. You can draw the inference because on the April 2nd transcript, you'll see at the very outset of the hearing, I raised the exact same issue with Judge Brady, and I said, you have to get an affirmation from the defendant himself personally as to whether or not he will pursue this defense. And counsel objected and said, no, 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 it's not relevant. Well, what could be less, you know, more relevant than whether or not he now, having been through this interview with Dr. Spears, now having a new lawyer, now raising this in a motion, what could be more relevant than whether or not, in fact, he wants that defense? And I think when the truth came out on page 203, the truth was, I don't want that defense. I don't want to be labeled criminally insane. I'd rather be in prison. That's Mr. Lang's choice to make. He made it, and he should live with it.
I've not looked that carefully at the record. As part of the record, is there an affidavit from Mr. Lang? There usually is for a motion for new trial, where there's a claim that I was not advised of certain things.
I don't believe there is. I don't recall one. I'd have to go back and review the record, and I don't believe he made an assertion about this. So, and the reason is because the theory here is, well, under Ribeiro, this is an absolute reversible error, no matter what else happens. If he doesn't get asked about this and make a choice at the outset about this, it's completely reversible. We don't need to know anything further from Mr. Lang.
Because the usual course, whether it be immigration advice or whatever else, is that there's an affidavit from the defendant that said, I never learned this, and if I had known this, I would never have pled, or I would have done something different.
Right, but here you have Attorney Sheketoff saying, I never discussed this defense with him. So you do have that on the record from Attorney Sheketoff.
And
However,
and what is your position as to whether that is a permissible course of action for counsel?
it is a permissible course of action in this case, and I would liken this to two other cases, Commonwealth versus Spray, which is 467 Mass. 456, and Commonwealth v. Walker, 443 Mass. 225. The Spray case is in neither brief. It's a fairly recent case, 2014. The Walker case is in the Commonwealth's brief. The defendant does not address it, even though we addressed it at the motion for new trial hearing. We brought it up with Judge Brady. We relied on it. He relied on it. The defendant simply doesn't address it. Now, to trigger the need to investigate, you need to have, obviously, a baseline of information. And while Attorney Sheketoff did hear from the defendant and knew from the prior motion of Attorney Parker there was a mental health history, what he did not have was a client who was having hallucinations or reported hallucinations. He did not have a client who was delusional or reported any delusional thought processes, which is very similar to Spray.
No, in Spray, though, the lawyer tried to get information and just ran up against sort of couldn't get it.
Right, I agree.
It sounds like Mr. Sheketoff had the ability to get at it, but chose not to.
Right, and part of the reason he chose not to, and this is because once, you can choose, there are different paths or different forks in the road, and when you choose a reasonable fork in the road, your duty to pursue and investigate the other fork in the road falls away, diminishes, and may cease to exist. The other facts that Attorney Sheketoff knew were that his client was reporting to him a self-defense case, and he said we would go visit him in prison. He wasn't delusional, he wasn't hallucinating, he was consistent in reporting a self-defense case, and Attorney Sheketoff testified that he reviewed the grand jury minutes, he reviewed the recorded witness interviews, he reviewed the police reports, he reviewed the forensic evidence. It was all consistent with a self-defense case. So it was consistent with what his client was telling him, it was consistent with a self-defense case. That gets him to a manslaughter and out of the murder verdict, and that's a good defense, that's a viable defense. So his duty to investigate the alternate defense, I would suggest, fell away, diminished, and ceased to exist as each of these facts comes into play and he realizes here's a really good viable self-defense case. And as this court said in Walker in affirming the denial of the motion for new trial there on the failure to raise a lack of criminal responsibility defense, when it's inconsistent with the defense you raise, when it undercuts that defense, then even if you don't present it, you don't get a new trial because you did have your fair trial, you got a reliable result, you pursued a good defense. The fact it doesn't work doesn't mean you get a second bite at the apple now to pursue a totally different defense.
Mr. Zanini, what weight should we give to Mr. Sheketoff's experience? Because, of course, he has a great deal of experience. How much weight, if any, do we give to that in the analysis?
I think that when you're looking at the first prong of Safarian, which is, did his conduct fall measurably below that of the ordinary fallible lawyer? The only evidence on the record of what an ordinary fallible lawyer would do is Attorney Sheketoff's own testimony. And if he establishes the standard, and he is the standard, then he couldn't possibly fall below it. He's done between 50 to 100 murder cases. He's done hundreds of felony cases. He said in his experience, he could recall only one successful insanity defense that he was ever involved in, and typically those work when the prosecution agrees. We truly have a not criminally responsible person. As you may know, sometimes those are bench trials where they go to trial and you get that verdict. He also was not aware of other successful insanity defenses. He said if there's a better defense, if there's another defense, you use the other defense. Juries are hostile to this, which I think is also recognized in Walker. The lawyer in Walker testified, and the judge, I believe the judge made findings to the same effect. So between Attorney Sheketoff and the decision in Walker, it's clear that the ordinary fallible lawyer does not pursue a criminal responsibility defense when there's another viable defense.
I guess my question would be, what if we were talking about a far less experienced lawyer who failed to investigate this as a possible defense?
Yes. You would still have the same result because the standard of the ordinary fallible lawyer would be at the same level. That standard is if there's another viable defense as established, as this court recognized in Walker, as Attorney Sheketoff said here, that even a less experienced lawyer who doesn't pursue a non-desirable defense when there's a viable, desirable defense that is preferable can't fall measurably below that standard, regardless of their level of experience.
With regard to the crime itself, I gather that he came into the bar, was not served because at least the bartender thought he appeared to be drunk. Was there ever any test done of the defendant at the time with regard to whether he was drunk?
There was no affirmative evidence that he was in fact intoxicated. So he walked into the bar with
There was no affirmative evidence? The bartender wouldn't serve him?
Walked in with beer.
He walked in with his own can of beer, and he was also not permitted to be in that bar. So
oh, I see. So he was barred from it because he was not allowed in the bar, not because the bartender thought he already had enough to drink.
Gee, I thought the transcript said that his breath smelled of alcohol and his speech was slurred, according to the bartender.
Well, he walked in with a can of beer.
I know that,
so-
but I thought there was also testimony that according to the bartender, the defendant's breath smelled of alcohol and his speech
That-
was slurred.
That may be, I'm sorry, I don't recall that, and it may be, but that in and of itself does not rise to the level of getting you an intoxication instruction in Massachusetts. The fact you've had a drink or two and you smell of alcohol and maybe your speech is slurred doesn't get you there under all of the cases in Massachusetts. You need a lot more evidence than that to be impaired by alcohol for purposes of a intent defense.
So there was no such instruction requested or given?
I think the judge may have referenced you can take into account alcohol in his instruction. I actually think he did mention that, and I can check and get you the page site if I see it there. But he was essentially being escorted out of the bar by several people. His story was that they were assaulting him on the way out of the bar, and that when he got outside, either in the foyer or on the street, that's when he drew a knife and he stabbed Richard Dever, and he slashed his face twice. He stabbed him 4 times, once in the heart. After doing this, as the defendant notes in her brief, at the end of her brief, he said, "How do you like your pretty face now, motherfucker?" So this is an intentional, vicious slashing and murder. That's what this is. And his best case was self-defense, to try to say he reacted because he was being assaulted by 4 people. That was his only defense. He went for a manslaughter. Any impairment by some sort of impulse control that went to lessening the degree or mitigating murder would have been, at best, to reduce the degree of murder. But the better defense here was self-defense and manslaughter.
I'm sorry, you say he was seeking to reduce the degree of murder. Did Mr. Sheketov argue in closing that the jury should find him not guilty because he acted in self-defense? Or did he admit that he had used excessive force in self-defense?
He never admitted that he used excessive force explicitly, but he at the end of his summation, he said that, I believe he explicitly said this is a manslaughter. So he did argue he was being assaulted, and he did explicitly ask for a manslaughter verdict. That's my recollection of the closing. On the courtroom closure issue, unless the court has questions, I'm simply going to leave that to the brief and the most recent cases from this court. On extreme atrocity or cruelty, I know that there's some opinions referencing vagueness and due process. I want to mention the Freeburg case, which is in 405 Mass. Freeburg was the most recent case I found where this court explicitly addressed due process and vagueness and extreme atrocity or cruelty and said this is a constitutionally valid theory of murder and verdict. I also think it's worth noting that subsequent to Commonwealth v. Gilbert in 1895, which laid out exactly what extreme atrocity or cruelty was, explicitly said it's a statutory crime, and that it's for the legislature to set. You know, since 1895, we've had that crime, and it's a statutory crime.
Didn't we define it in Cunene?
Well, what Cunene did was, so Cunene took a variety of factors from other cases that other cases had already said, yes, these are factors. And Cunene just compiled a list and said, oh, here's the list of factors from these other cases. It's not like Cunene created new elements or added anything to the pre-existing law that I can see. Gilbert is 165 Mass at page 58 and 59 is the relevant language.
Now, at trial, was there an objection to the extreme atrocity or cruelty instruction?
Well, at the end on the instruction, Attorney Sheketov did say, you know, I object to that because I don't understand it. I don't understand the difference between first and second degree murder. But this court clearly in Freeburg...
But he did not object on the grounds that you must intend to commit a crime that is atrocious or cruel.
Well, he said he didn't understand the difference between first degree and second degree murder in terms of the intent.
Okay, but that's...
So he was objecting to this theory of murder, yes. And he was objecting on the ground that he said, I don't understand it, it's vague. But since Gilbert and all the way through Freeburg, it's clear that it's not vague, it satisfies due process, and in fact, when the legislature has subsequently amended or reenacted the murder statute, they've explicitly adopted and made those elements, the two elements under extreme atrocity or cruelty, as a statutory part of the crime. And as you know from the Diachenko case, that at least in 1982, they amended and readopted the murder statute, which means they statutorily, created the elements of this crime in a specific way by incorporation. And most recently, in August of 2012, as you know, there was an amendment to the sentencing statute for juveniles in terms of parole eligibility for murder. And in that statute, there are 3 different time frames for parole eligibility for murder for juveniles. My recollection is it's 20 years for felony murder, 25 is the maximum for parole eligibility date for a deliberately premeditated murder, but it's 30 years minimum parole eligibility for an extremely atrocious and cruel murder by a juvenile.
Mr. Zanini, did you say that was a 2012 amendment? That was just a recent amendment.
Maybe it was August of 2013, right. I can get you the date on the Public Act. What I have is Chapter 189, you're correct, Your Honor, Chapter 189 of the Acts of 2014. So that would have been August of 2014. So the legislature has clearly recognized this form of murder, and that this form of murder is far worse in the view of the legislature than either deliberate premeditation or felony murder. So I would suggest that if the legislature wants to amend that form of murder, that statute, it's for the legislature to do. And I would ask you to affirm the verdict of first-degree murder.
Thank you.
Thank you, Counsel.
Thank you.